Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our Workers' Compensation series. I'm Sherri Dougherty, and I'm presenting today with Paul Fires here in the Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you'll find a copy of this presentation and others under the Weber Gallagher University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Professionally Administered Structured Settlements, Increasing Benefits, or Impending Opportunity. Let's get started.
Hello, everybody. My name is Paul Fires. Structured settlements. It's become very popular in our field to structure settlements, whether it's indemnity or medical, and we're going to talk today about some of the benefits and pitfalls with those settlements and how those settlements can work to the benefit of both the employer and its carrier, as well as the injured worker. So what is a structured settlement? A structured settlement is a legal settlement that's paid out as an annuity rather than as a lump sum, resulting in savings for the payer. Why is that? Because basically what you're saying is you want to be able to provide a lifetime of benefits at a certain dollar value, but purchased with today's dollars. So based on current interest rates, you will get a discount off of that, and the individual will get a regular payout of benefits over time equal to the total payout of the settled amount. That's fundamentally what an annuity is, and that's a structured settlement.
There are a lot of benefits to the injured worker of structuring a settlement. The first would be that you get a full case settlement for the injured worker with spending cash. So instead of the injured worker getting a small check every week or biweekly with a deduction of attorney fee from that check, they're going to get a lump sum settlement, but they're also going to get some money to use in the future for their future medical or other issues that they may want to use money for. Another benefit to the injured worker is that there's a departure from the workers' compensation system with an end to contentiousness. So basically, the injured worker is splitting with both the insurance company and the employer. They can move on with their life. They won't have to engage in further litigation regarding payment of medical bills or reduction in their benefits. They won't have to attend IMEs, they won't have to attend IREs or vocational evaluations. It's a complete end to their workers' compensation case, but they are going to continue to get some money either for future wage loss or future medical.
Sherri, do you think that's something injured workers might want?
Yeah, I think it would be. I mean, a lot of injured workers always complain, one, that they don't have enough money. Here they're getting a lump sum that's guaranteed to them. There's also a situation where injured workers are refusing to settle their workers' compensation case because they feel that they need a lifetime of medical treatment. So with the option of the structured settlement for future medical, they are going to be able to continue their medical treatment, and we'll be talking about that a little bit later as well. It also protects the injured worker from improvident spending of cash or medical settlement portions. So they're not just getting one lump sum and that's supposed to last them for the rest of their life. If you structure the indemnity portion, they're going to get some amount of cash up front, but then periodic payments for a specific period of time. And then with regard to the medical settlement portions, the same thing. They will get some upfront seed money to start off paying their medical treatment, and then typically it's annual payments to continue their medical. So they can't go out and buy a car with it or pay off their mortgage or pay their credit card bill and then say, well, the settlement wasn't enough. Here they're guaranteed some additional money coming in the future.
And that sounds like a great protection to me, but there's still more protections available. When you're working with the carrier pays medical bills at scheduled rates, but oftentimes an injured worker, when they're on their own with a cash settlement, can't take advantage of that, even though the settlement might have been priced at scheduled bill rates. What happens when you have a professionally administered structured settlement on the medical side, often discounts are available to the administrator, and that provides a way to have the money last a whole lot longer in the claimant's account or the injured worker's account. Typically also, there's year-over-year funding rollover for any unspent medical money. Some people, and this has been documented, tend to treat a little bit less when their cases are settled. Not everybody does, but some people do. Or perhaps they get a job with an availability of medical benefits, or perhaps a spouse has medical benefits and bills start going in that direction. So the point is, when some of this money is unspent, it can roll over from year to year and create quite a large fund over time for additional money to be paid to the injured worker should there be a medical emergency or an extreme need. Now, with continued professional administration of the medical billing, you have that kind of protection, and most importantly, that provides record-keeping services for Social Security and Medicare purposes and their administrations, so that all of this record-keeping allows the injured worker to use Medicare when necessary, because the backup is maintained by the professional administrator in a professional way.
Paul, what is the difference where you have the claimant self-administering future medical set-aside versus using professional administration?
Well, that's a great question, because he or she would have to keep scrupulous records on a regular basis, month after month, year after year, of what they spend, how they spend it, where the bills are, and whether you're technologically qualified or not, those records have to be properly and orderly maintained. Because if you run out of money in any given year, you want to be able to go to Medicare and have them step in and pay as they should. But unfortunately, they won't unless those records are there and available. But with professional administration, that's the service you're paying for, and that's typically paid for by the injured worker's employer. All of that is done for the injured worker. They don't have to worry about it. And finally, another benefit would be estate protections versus workers' compensation benefits. What do I mean by that? And this sounds a little bit gruesome, but it's true. Workers' compensation benefits end when the injured worker's life ends, typically. And that could be in the short term, that could be hopefully in the long term. But if it's in the short term for some unwork-related cause or unexpected accident, there's no protection for the injured worker's estate. But if you have a properly structured annuity, you can provide substantial protections for the injured worker's estate and their beneficiaries.
So would that be a benefit for some of our older injured workers as opposed to somebody that's in their 20s or 30s?
Frankly, I think it's both, because accidents can happen to people in their 20s and 30s, just like older folks can suffer health emergencies and sudden demise based on other non-related work-related medical conditions. It's just a good way to protect your estate and the heirs that you name in your estate. Let's talk about some benefits to the employer and carrier. This method allows a full settlement of some of the more complex cases for financially certain sum. And those complex cases, I'm sure those of you who have them, are extremely difficult to try and value, extremely difficult to try and settle, principally because a lot of lawyers who protect their clients effectively don't want to see them having responsibilities that they're not skilled to handle. So when you have a good structured settlement with professional administration on top of it, it gives that type of comfort to the attorney that the attorney can recommend it to his or her client. Now, once that case is settled, you'll see a substantial reserve reduction. And the name of the game in so much of risk management is making sure that reserves are adequate for cases that are open, but then released when cases are closed. There's also protection of the settlement money from being drained by improvident spending, as Sherri mentioned. And I think all of us know stories about how people have been given cash settlements, and unfortunately some of the money ends up going on things that it shouldn't. And it could be something as basic as a television set or as exotic as a racehorse. I've heard just about every story under the sun. This prevents that from happening. And again, although there's continued relationship, it's less contentious with the oversight of the medical spending. Why is that? Because there are no utilization reviews, there's no medical challenges. If it's nominally related, the administrator will pay the medical bill directly.
And Paul, can these structured settlements for future medical, can they be a good option for cases where the carrier may have settled indemnity years ago, but they have a medical open because the claimant's refusing to give up medical treatment?
Exactly right, Sherri. And I have seen time and time again that the fundamental reason why an injured worker might not have wanted to settle the medical portion of the case is because they didn't trust themselves to properly handle the money and make sure that the money would be there. This gives them the comfort and security to know that there's professional administration, there's a fund that's going to be paying money into their medical expending account on an annual basis, in addition to seed money, so that their needs will be met, and then Medicare can step in at the end.
Now, in addition to the benefits to the injured worker, there are some downsides to the injured worker. First of all, the workers' compensation carrier and the employer are no longer involved in the case. There's also a potential for insufficient funding, and this is what Paul talked about before, where for future medical, you're going to get some initial seed money, you're going to get some annual payments. If you are receiving more medical treatment than what was allocated for in the medical set aside, you may have insufficient funding, but that's where the administrator is going to help you to get Medicare involved to pay for those medical treatment that's over and above what's been allocated in the Medicare set aside. And as we stated, this is some of the benefits of having an administrator to keep track of all your medical spending and to keep track and help you with Medicare should the need arise.
But Sherri, I bet it's also really important to have these priced correctly at the outset, isn't it?
It is. And so what we typically do is you want to review what the Medicare set aside or a future medical allocation is provided either by the carrier or by a vendor, and make sure that that's consistent with the type of medical treatment that claimant has had in the past for their work injury and what they are expected to need in the future. There's also a downside with uncontrolled and unprotected by the state's Workers' Compensation Act. So as you know, under the Pennsylvania Workers' Compensation Act, the carrier needs to pay for reasonable, necessary, and related medical bills for as long as the claimant needs medical treatment. If you do a full compromise and release and the medical treatment is now in the hands of an administrator, the claimant or injured worker does not have the opportunity to go to the courts and file a penalty petition if certain medical bills aren't paid. There's no fee reviews, there's no utilization reviews, so that could be a problem for the injured worker if they are seeking some medical treatment that maybe wasn't anticipated in the Medicare set aside or a new type of treatment.
And of course, as we all know, once the case is settled, it's done. No one can come back, correct?
Correct.
So the other downsides to the employer carrier include the fact that when there's the potential for insufficient funding, it means that the injured worker was not adequately protected. And I think all of us would agree that our role as the employer, as a third-party administrator, as the insurance carrier, is to provide adequate protections for workers who are legitimately injured. And that's what we all do in part for the living. For a living. So making sure that these are adequately and appropriately funded and fairly funded at the outset is critical. Another downside is the very rare possibility of the insolvency of an annuity company or professional administrator. And that should always be backstopped by a plan B should that happen, and that should be in all of the contracts and paperwork so that the injured worker is not left without an alternative source for professional administration or funding. And ultimately, the fundamental downside, and this may be an upside to some, but it's also a downside, is that you are relinquishing control of the case. But if you're relinquishing control of the case to someone who understands fully what they're doing in accepting that, then I think it's appropriate for the carrier and the injured worker to move on.
So Paul, instead of the injured worker having a relationship with the employer and the insurance company, they're now more in a contractual relationship with the administrator?
Right. The administrator is contracted to provide these services to the injured worker for as long as the contract requires. But I do think that it's important to have that backstop just in case something happens. I don't really hear of it happening, and you and I, Sherri, both have been doing this for a very long time, but anything can happen, so having a backstop plan is a good idea.
There are various types of structured settlements. So first, you can have a structured settlement of the claimant's future wage loss. And basically, as we stated before, typically someone would get some cash up front, and then periodic payments. So the periodic payments can be set up to provide payments until the claimant's death or for some term that may go beyond their death. And that is beneficial to the claimant for some of the reasons we already talked about, that there's not going to be the improvident spending of their entire settlement within the first year, where you may have a claimant with a 20 or 30-year life expectancy. And depending on what the current interest rates are, these can or cannot be beneficial to the claimant. Sometimes they're a bit hard to sell to the claimant to not get all their wage loss benefits up front. And then we have the future medical set aside. So you have a Medicare set aside that can be done with a structured settlement, and that would be professionally managed by a administrator who, as we said, would handle all the medical bills. They would contract with different providers to get good discounted rates on the medical bills. They would provide all the record keeping that the claimant requires for Medicare purposes, and they would help the claimant get medical bills paid through Medicare should the amount of money in the Medicare set aside not be sufficient. You can also do a structured settlement to cover future medical expenses which are not covered by Medicare.
What would those be?
Well, the biggest area that I've seen it is when the claimant might be taking a medication that is not for its official use as approved by the FDA. Like I know one of the big medications that's been in non-Medicare covered benefits would be the medication Lyrica.
Right.
Lyrica is essentially a medication that was approved, I believe, for seizure activity. Most of our claimants do not have seizures and are not taking it for seizures. They're taking it as part of a pain management regimen, usually for nerve pain or post-surgical pain. And Medicare does not pay for it under a Medicare set aside. So if you have a claimant who is taking that and their treating doctor says they're going to need Lyrica for the remainder of their life related to this work injury, that can be a significant cost to the claimant if they settle their case and don't account for that prescription for Lyrica. So it would be medications that are being offered off label and other things that are not currently being covered by Medicare.
Speaking of off-label, I have a tough question for you. What about cannabis?
That's a really good question because, as you know, that's really new in Pennsylvania, and we have not seen any specific case law. The medical marijuana laws in Pennsylvania essentially do not require an insurance company to pay for medical marijuana yet. So that's a question that I really don't know the answer to.
I'll tell you where and I've seen it. If there's regular cannabis use involved with the claim, I don't see carriers covering that throughout the life of the claim. But when the claim is brought to conclusion, I have seen some money allocated, not specifically for cannabis, but allocated with the knowledge that if a claimant feels that he or she really needs that, there's some extra money put in there for it. So I'm already seeing this happen in the world of carriers and third-party administrators, that there may be some allocation of money for, again, a non-covered Medicare item.
Right, and that's just another thing to discuss with the injured worker and their attorney when you're negotiating a settlement, to say, hey, here's some money that we're allocating towards future indemnity, future medical, and also future use of cannabis, which is not something that the insurance carrier is currently paying for. So I'm really interested to see what's going to happen in that realm.
Me too. So there are a couple of different types of structured settlements that are used by most carriers, and they fall into the category of temporary life annuities and whole life annuities. Let's start with temporary life annuities. Why am I starting with them? They tend to be less expensive. Temporary life annuities are paid for a specific period of time, and only if the claimant is or the injured worker is living during that time frame. So let's say it goes for a period of, pick an unlucky number, 13 years, and the individual passes at year 2, the payments would stop. And again, this is typically less costly for a carrier. Then there are whole life annuities. What are those? Those are paid for the claimant's entire life, and priced based on the claimant's age or rated age. And these are typically much more costly for the carrier. And when I say much more costly, that depends on the length of time that's being contemplated. But if you're trying to do this for a younger individual, this can definitely be where the cost is. How do you know to do one or the other? My recommendation would be to look at the case as an individual case and see what's best for the injured worker, coupled with what's best for the employer and the company. At the end of the day, we tend to see temporary life annuities overwhelmingly offered most of the time and accepted by the injured worker. On much rarer occasions, and in case appropriate situations, we see whole life annuities. Now let's talk about some of the pitfalls of using the structured settlement. For the injured worker, the rated age mechanism could leave insufficient funding, as Sherri pointed out. We've already discussed the issues concerning financial health of the administrator and the annuity company, which is why we suggested the backstop. And we've mentioned that there's no court mechanism for relief. If this does go wrong in some way, the settlement is full and final. Let's also consider this issue. Over the life of an injured worker, there are always new treatments coming down the pike. And as I think we all know, some of those new treatments can be very costly, at least in their initial stages of use. When these new and costly treatments come out, it's probably not budgeted for in the MSA and Medicare stopgap. And that could be a problem for the injured worker if he or she wants to take advantage of that. And of course, there's the medical choice issue as well. So do keep in mind that when you close your case, you are losing out on an opportunity to have priced within the case, if you're the injured worker, these newer treatments that may be coming down the pike.
What is rated age, Paul?
That's a great question and an interesting one too. Rated age takes into account a natural life expectancy based on some of the standard issues, gender, race, geographical location where you come from, but also comorbids that the individual might be suffering from, unrelated heart conditions, unrelated stomach conditions, cancers, things of that nature. And what that does is it comes up with an age that isn't the natural life expectancy, but the life expectancy when you bring in all of these other comorbid conditions.
We hear a lot today about the opioid epidemic, especially here in Pennsylvania. Does that factor in at all to rated age when an individual is on a lot of opiates?
I think it's pretty well understood that excessive opioid usage over time, assuming there's not an overdose, let's first make that assumption, will eventually cause organ breakdown and failure and lead to a perhaps untimely or early death. There's also, I think, the real risk that uncontrolled opioid usage can lead to overdosage and death. It can also lead to the using of other drugs and sometimes even street drugs to manage an individual's high. Rated age companies all work a little bit differently, but I would suggest this: if you're dealing with an opioid addiction issue, I would work very closely with the rated age service to make sure that all factors are considered when the rated age is being developed.
There are some additional benefits of using the structured settlement. The injured worker can roll over from year to year any unspent money. So if there's other insurance available that the injured worker may be able to put medical treatment through, such as coverage through a spouse, they may have gotten a new job that has insurance, they may be able to hold over some of that unspent money year to year and have additional money for the future. There's also the opportunity to have a reversionary interest back to the funder of the annuity for monies that are unspent at the time of the claimant's death. And as we said before, there's also more medical choices with using the structured settlement.
Well, thank you very much. This concludes our webinar today. As we stated previously, you have an opportunity to ask your questions, and we would be happy to provide you with answers. We would like to thank everyone for attending our webinar, Professionally Administered Structured Settlements, Increasing Benefits or Impending Opportunity. Again, if you would like to learn more about this program or others offered by Weber Gallagher, please visit www.wglaw.com/WG-University. Thank you very much and have a great day.